Hey there, everyone. Attorney Jason Cromie here from Pensacola, Florida, with another session of the law in a way that people can understand it. The topic I wanted to cover today, again, we're going to stay in the DUI zone. Common question or statement that comes up during an intake with a client is they didn't read me my Miranda rights, or should they have read me my Miranda rights? It's a good question, something we all think about when it comes to an arrest. But the way it works in a DUI case is a little different than some other cases you typically will see. As a general rule, you only have to be read Miranda by law enforcement if you are in custody and you're subject to interrogation. What does custody mean? Custody is being arrested, or the functional equivalent of an arrest. So what that means is that if you're stopped on a traffic stop for running a red light or not wearing your seatbelt, that's going to be a traffic stop for a civil citation. The law does not find that to be the equivalent of an arrest. So in that scenario, you typically will not have to be read Miranda at that point, which is where it gets kind of weird, because what's the first thing the officer is going to ask you in a DUI case when he walks up to the car and smells what he thinks is alcohol? The cop's going to ask you, hey, have you been drinking? Do you have to answer the cop's question? No, you don't. You always have the right to remain silent. It's just that they don't have an obligation at that point to advise you of your right to remain silent. So you can always tell an officer, I'm not answering your questions. I'm not comfortable talking to you about this. But just know that it's not something they have to ask you at that point. When it comes to field sobriety exercises, does Miranda apply at that point? So the officer says, well, why don't you step out of the car? If you don't mind, I'd like to conduct some field sobriety exercises to dispel my suspicion you may be impaired. Does Miranda kick in? The answer is no, because the way you walk and move your hands and, raise your foot and stuff are not testimonial. And that kind of gets to the second part of Miranda, but it deals with things that happen in custody when you're interrogated. So again, it's not testimonial. You're not going to be saying anything or answering questions if you're just holding your foot up for 30 seconds or touching the tip of your nose with your finger. The court's not going to find that that is testimonial nature, so Miranda doesn't apply. So you get arrested for DUI and the officer says, will you submit to a breath test? Does Miranda apply at that point? Well, lots of folks, ask the officers, I want to speak to a lawyer at this point. I didn't want to do the exercises, but I agreed because I wanted to do the right thing. Here I am in a situation where I'm now being arrested for having decided to do the right thing and try and cooperate. I don't know if I want to cooperate anymore. I want to speak to a lawyer. Well, unfortunately, Florida law does not give you the opportunity or the right to consult with an attorney about whether or not to take that breath test. And the officer is going to tell you that. He or she is going to say, you don't have the right to a lawyer right now. This is not interrogation. This is not questioning. We have a video on whether or not to provide a breath sample. I refer you over to that one about refusals. But really, after the breath test is done or it's refused, as a general rule, that's when they're going to read you Miranda in a DUI case. The reason for that is they have a sheet that's got a list of questions that they want to ask you about. Were you driving a car? Had you been drinking? When's the last time you slept? When's the last time you ate? How many drinks did you have? Where were you coming from? What time is it now? What direction were you traveling? Do you feel the effects of alcohol? Do you wish you made any different decisions this night? You can see how all these questions are designed to pen you in to help them make a case against you. So when they read you Miranda at the end of your DUI arrest and say, well, would you mind answering some questions for me? As a general rule, the answer is no offense, but no thank you. Okay. Remember, when you finally do get read Miranda, you have the right to remain silent. And my advice typically is that you use it. Okay. If you have any questions about this, always feel free to call the office. We are here to talk with you. Consultations are free. And we look forward to speaking with you shortly.